Hello, my name is Thorne Barasa, the president of the ICJ in Glance. And for our final class in this series, we shall look into judgment and enforcement. And we look into the structure of the judgment, the binding nature of the judgment, how enforcement works, and how this applies to MUN judges. Now, you have brought your case before the court. You have done an application. You have done your memorials. You have argued out your case. Then comes the part all of us have been waiting for, So what has the court decided? Who's won? And to what extent? So the judgment is a court's authoritative resolution of a dispute. It is the outcome of a judicial deliberation where the law has been applied to the facts and a deliberation or a decision has been made. So it's the authoritative decision or resolution to a dispute. It has a very easy structure. Of course, there's the introduction, which identifies the parties, the nature of the dispute, and provides a brief overview of the proceedings. The judgment then moves to the question of jurisdiction, which the court confirms whether it has the legal authority to hear the case, which is addressed before examining the merits. And then now there's the examination of the merits, where through statement of facts and legal reasoning, the judge or the judges now say, we have had this side say this, we've had this side say this, this is what the law says, and according to the situation, this is how it came out, and this is what the court has decided. And then, which comes to the operative clause, which is now the ruling, which is the final decision, that clearly states what the court has decided, any deliberations made, any remedies granted to any of the parties. But the importance of the ICJ judgment is also a matter of importance. And as you've said, the ICJ judgments are legally binding to the parties of the dispute. So if the court has said State A will pay State B, State A needs to pay State B. This does not mean that State C will be obliged to pay State D the next time when this happens. But the judge can use the fact that when this situation happened before, State A paid State B, so State C should pay State D. But State C will not pay State D because previously the judge said State A should pay State B. So our judgment only applies to the parties in the dispute. If it's Kenya versus Uganda, the judgment applies to Kenya and Uganda. The judgment would start applying to Chile and Brazil just because the judge ruled this way. So they do not automatically create precedent for another state. So the binding effect is limited to the specific case before the court and the parties involved in the proceeding. But they carry enormous persuasive authority in future cases, and they help the development of the law. So if situations are evolving and we're seeing that the court has now started departing from this position, you can follow that through the judgments. What about enforcement? As we said, unlike domestic courts, the ICJ has no enforcement mechanism or like police to be able to do that. And the states are expected to comply voluntarily based on good faith and international reputation. Why is this important? Because if it so happens that we hear that a state has decided not to follow a court order, it sends a message to other states, and states will be more unwilling to get into treaties with them, more unwilling to get into business with them. So there's also a political goodwill within the reason as to why states are expected to comply voluntarily with these decisions. And if a state fails to comply, another party may refer the matter to the UN Security Council. So, of course, as I've said, it comes down to consent. So let's assume one state decides, no, I'm not going to follow this judgment. That is then followed, or rather forwarded to the UN Security Council, which then will mean that the state has to appear before the UN Security Council. And the Security Council will decide what measures to take. It might issue sanctions. It might decide to pull the state out of these treaties. And of course, that means that enforcement becomes more difficult when more powerful states are involved. and states whose names I won't mention, but when more powerful states are involved, enforcement becomes a bit more difficult. And well, as we've said before, even in advisory opinions, these are now the legal outcome of when the UN agencies or UN bodies have sought the opinion of the court, and they are issued at the request of the UN agency or the organ. But for contentious judgment, it would be binding to the parties. So, what are the roles of the judges in MUN, especially with delivering judgments? 1, they need to assess jurisdiction to ensure that the court has the legal authority to listen over the case. They need to evaluate the arguments, the way the arguments presented by the agents, and accord marks to that. Of course, they do this by applying the law and applying the sources as stated in Article 38 and delivering the judgment and delivering feedback to the team as well. So this more or less enshrines the entire process, where we started by looking into the court, how to bring a case before the court, written submissions, applications, oral arguments, and then the judgment. And with that, ladies and gentlemen, we have come to the end of our series. Thank you very much for being part and parcel of this. Should you have any questions, you can always ask them in the comments, and we shall make sure and to do our best to respond to all of them. Thank you very much, and I shall see you on the next one.